All right, everyone. I hope you are ready with the solution to these questions. Yes, there were just two questions in the first unit. It's like a warm-up session for all of us. And over here, you will also come to know what is the correct way of writing the answers. Now, before I discuss the solution with you, let me first discuss the format in which you are supposed to write the answer. Now, you will divide your answer into four parts. You will first start by writing provisions. If you notice, students, this is how I had prepared the pro forma also for you. First, you will just write the provisions followed by facts of the case, analysis and conclusion. So the format was also given to you in the same manner. See, first you will write provisions. Now, in your answer, let's see, this is your answer sheet, all right? You will write question 1. Okay. Then this, let me assume that this is your margin, so you will know exactly the kind of paper presentation that is required. So write question 1. Then you will write the first question, then the first one. Okay. So this is the sub question. You will write provisions. Just give the heading. Okay, you have to write the heading. You have to write that word. Write provisions, put a colon, underline this, and then leave this part. Okay, leave this space blank. From the next line, you will start writing the provisions. You can write it in paragraph form, you can write it in point form. Any kind of format is accepted. Now, I will never advise you to write bullet points. Okay, don't draw a bullet. Write small 1, small 2, or write A, write B, whatever you want. Don't draw an arrow, don't draw a star, don't draw a dot. Okay, all this is not accepted in the exam. You can write small 1, small 2, or you can write small a or small b. That I leave up to you. You need not even leave a line after writing the provisions. But if you feel that your handwriting is very big, it is untidy, then you can leave a line and then write all the provisions in a point format. If you don't want to write it in a point format, then just write the sentences one after the other, okay? So just go on writing in paragraph form, all right? So I leave it up to you. There's no fixed format for writing that. After you write the provisions, you will leave a line. Okay? When you finish writing the provisions, you write it in point format, you write it in paragraph format. I have no objection to any kind of format that you follow over there. Leave a line and then you will write facts of the case. No need to number all this. No need to write provisions is A, facts is B, provision is 1. No need to give any number to provisions, facts, okay? That heading does not require a number. Then you will write facts of the case. Underline it, okay? You leave a line. This, I left this line. Then write facts of the case, underline it, leave the space over here and start writing the facts in your own words. Now, this is the format. Let me also highlight what exactly you are supposed to write in provisions. You will quote the section number, name of case law, if any, and only the theory related to that question. Okay, only the theory. I am not going to now discuss the question in provision. I'm only providing the theory. I'm just impressing the examiner that, see, I know the background which is, or the provisions which are applicable to this question. In facts of the case, there is one alternative which I would like to suggest. Sometimes students prefer writing the name of the case law in the provision itself and putting it in a box. Okay, if you write the name of the case law anywhere in the provision, just put it in the box so that you're highlighting the name of the case law. But there are certain students who feel that, no ma'am, we would like to put a separate heading for the case law. Then you can also write reference case law. Okay, give the heading reference case law and write the name of the case law. So let's say, for example, you write Carlyle versus Carbolic Small company. So just write reference case law, and you can also write the name of the case law as a separate heading. So there's no fixed format. Whatever you feel comfortable, you can follow that. So write the provisions. In that you will include the section number, name of the case law, if any, theory. If you want, you can write reference case law separately and then write the name of the case law. Okay. So there are two ways of writing the case law. At this stage, students also ask me, ma'am, is it required to explain the case law? Is it required to write the facts and the judgment of the case law? You need to write the case law, the facts in your own words, only if you feel that there are very less provisions which I can write in the exam. Let's say there are only 2 sentences which I could manage in the provisions part. I don't know the theory, okay? Or maybe the theory is very less. I am able to write only 2 sentences. Then in that case, explain the case law. That will create length to your answer. If you feel that I have a very high writing speed, I will be able to manage my time, I will be able to write everything, then you write the facts of the case. Sometimes facts are mentioned in the model answer, sometimes they are not. So even the examiner is not very particular about it. If you feel that you are able to write the facts in your own words very quickly, you will be able to manage, your time, then I would encourage you to explain the case law in brief in your own words. Okay. So this is how you will draft the provision. You will write the section number, you will include name of the case law, you may write the facts and judgment of the case law in brief, okay, in brief, and then you will also write only and only the theory related to that question. In facts of the case, you will write the question in your own words, okay. You will mention question in your own words, okay, in your own words, very briefly. There are no marks for writing facts of the case. It is just paper presentation. So don't waste time in writing elaborate facts. You are just repeating the question. Examiner is already aware of the question. So don't waste time in this. So you will write the facts of the case. After that, you will write analysis. In that, we will provide some solution. Now, what is the common mistake made by many students? They directly jump to the conclusion. No, you need to write at least 1 or 2 sentences of the question and then arrive at the solution. So don't just write yes, no, and you don't just write the solution directly. First, write 1 or 2 sentences of the question and then you arrive at the solution. So basically we are writing the solution. In this case, maximum marks are for provisions and analysis. So please pay a lot of attention to provisions and analysis. After you write the solution, then you will leave a line and give the heading as conclusion. Now, please pay attention, students. State with reasons whether Sun can recover the amount in the Contract Act. Now, what is the question asking us to conclude? You have to decide whether the Sun can recover. So whatever is asked in the question, okay, last sentence, whatever is asked over there, that will be answered in the conclusion. See over here also. Advise whether Miss Lali will succeed. So in the conclusion, you have to write, considering the above facts and the solution, Miss Lali will succeed or will not succeed. That one line will come in conclusion. You take any question, whatever is asked over here, okay, that is actually something which you should answer in the conclusion. So in conclusion, I will give the heading. I can start my conclusion with hence, therefore, thus, so, it is so concluded, from the above, we conclude that, okay. So in this manner, you can just pick up whatever word you feel is right and then write the conclusion. Now coming to the length of the answer. Provisions, write as much as you can, okay, write as much as you can. Facts of the case, just write 3 to 4 sentences, that is sufficient. Analysis also 3 to 5 sentences are sufficient. In conclusion, 1 or 2 sentences are sufficient. If in the main question they have asked sub questions like 1 and 2, so you will have to answer both separately. So in the conclusion or analysis part, you will say 1 and 2, you will provide the solution separately. Okay, so as we progress, you will also come to know what is the format in which the answers should be framed, but more or less this will give you an idea. You must have also received one. Okay, this, I hope you wrote all this in your book. Yes, you must have also received a question answer booklet from me. Yes, these are the questions which are printed behind every chapter. Okay, so these are the questions printed behind every chapter and their answers. So this particular booklet consists of the questions which I have mentioned in writing practice and their answer, their model answer. So you can check your answer with these model answers, and the marking scheme also will be discussed over here. So you can give yourself marks. Now, father promised to pay his son 1 lakh rupees if the son passed the CA exam in the first attempt. Wait, students, I am going to train you on how to frame the answer while reading the question itself. I'm going to train you, I will teach you how to arrive at the answer while reading the question itself. What are the words that will give you a hint of the answer? So father promised to pay his son 1 lakh if the son passed his exam in the first attempt. Now father is promising to pay his son. This is a domestic agreement. So immediately my mind started framing the answer. This is a domestic agreement. There is no enforceability because we assume that parties do not intend to create legal relationship. There is no enforceability. There is no presumption of enforceability. Okay. Son passed the exam in the first attempt, but father failed to pay the amount. Son files a case. Will he be able to recover? I'm already ready with the answer. This is a domestic agreement, but that will be just 2 sentences. This is a domestic agreement. We assume that parties do not intend to create legal relationship. Hence, son will not be able to file a case. We have to create a proper answer for 4 to 5 mark question. So how do we do that? Okay. Now, because this question is related to domestic agreement, which is a part of enforceability, explain the entire concept of enforceability in the provisions part. Okay. So in provisions, now these are the pointers. Okay. In provisions, you will write something about enforceability. Ma'am, can we also define contract, because enforceability is the only component, it is the only element which distinguishes agreement from contract. Yes, of course you can write it. So you can also write the definition of contract. Okay, so we can write the definition of contract. Now, contract is defined under section 2 clause H. If you're writing the definition, I will always advise you to also write the section number. So definition of contract, okay, then we will explain enforceability, or I'll just move it over here so that, you know, we have a proper sequence. I'll just change this. So this is 1. Enforceability is 2. Now elaborate enforceability. In case of business or commercial transactions, there is a presumption of creating legal relationship. We assume that parties intend to create legal relationship. However, in case of domestic agreement or social agreements, there is no such assumption. We do not assume that parties intend to create legal relationship. There's no such assumption. Now, after you define contract, after you explain the concept of enforceability, you can also write enforceability means intention to sue, intention to file a case. If one party defaults, other party can take action. In case of business or commercial transactions, we assume that parties intend to create legal relationship, but in case of social or domestic, there's no such presumption. So there are so many points which we can write in the provisions itself. So explain enforceability, and also explain that there is a presumption in case of business or commercial. There is no such assumption in case of social or domestic agreement. Now let's see if our provision is matching with the model answer. As per section 2 clause H, contract is an agreement which is enforceable by law. So we have written the definition of law. Our answer is matching with the model answer available with the examiner. He will give us marks. Domestic and social agreements, they are not enforceable by law. Okay. They have also mentioned the case law. This I forgot to discuss with you. They have also mentioned the case law Balfour versus Balfour. So because I did not discuss that, I will write it in red so that I always remember that yes, there was a case law. We could have discussed and mentioned that case law also. Balfour versus Balfour. Okay. Now, here they have not explained enforceability, but I think you should explain enforceability. Enforceability means intention to sue, intention to file a case. If one party defaults, other party can take action. In case of business or commercial transactions, there is a presumption that parties intend to create legal relation. But in case of social or domestic agreements, there is no such presumption. We assume that parties do not intend to create legal relation. As per the facts of Balfour versus Balfour, a husband promised to pay maintenance to his wife so long as they remain separate. He failed to pay, wife filed a case because this was an agreement of domestic nature. She lost the case. Okay, it was contemplated, it was decided that there was no intention to create legal relation, hence she lost the case. Imagine writing all this. I think half a page will be filled with the provisions itself. The examiner will have to give you marks. Because you have spent so much effort in writing the provisions, explaining the case law, you need not write a lot in the analysis part. You can directly give them the solution. This is a domestic agreement. You can also say, like I had mentioned, don't just directly jump to conclusion. Say that this is an agreement between father and son. This is an agreement between father and son. It is a domestic agreement which is not enforceable by law. Applying the above provisions, we can conclude that son cannot recover the money because it's a domestic agreement and they never showed any intention to create legal relation. Did the son tell his father that you please give a written agreement, let us sign it, write it, register it? There was no intention to create legal relation. That is why the son will not be able to recover the amount from the father. Did you notice something? The son cannot recover the amount from father was written in analysis and it is also written in the conclusion part. There is a repetition. So we not only provide the solution in analysis part, but we also write that as a conclusion. Why did we write this over here as conclusion? It is because the question said, will the son be able to recover the amount? So we have to answer that in the conclusion part. So we will say that the son will not be able to recover the amount from father. If this is a 4-mark question and I am the examiner, okay, if this is a 4-mark question, I will give 2 marks and it can also be 2.5 because you are also explaining the case law. So if I am the examiner, I will give 2.5 marks for writing the provisions and 1.5 mark for writing the analysis and conclusion. So let's say 1 mark for writing the analysis and half mark for writing the conclusion. So maximum weightage will be given to provisions because you are explaining contract, you are explaining enforceability, you are explaining business and social domestic, you are also explaining the case law. So because there is a lot of content to be written in the provisions part, if I am the examiner, I will give 2.5 marks allotment to the provisions, then 1 mark to analysis and half mark for conclusion. Mr. Ramesh promised to pay 50,000 rupees to his wife, Miss Lali. Again, husband, wife. This is a domestic agreement. So he promised to pay 50,000 rupees to his wife so that she can spend the sum on her 30th birthday. Now she insisted that you make a written agreement if he really loved her. So he made a written agreement and they also got it registered. Okay. Mr. Ramesh failed to pay. Now she wants to file a case. Will she win the case? In spite of this being a domestic agreement, because the agreement was in writing, it was registered, there is enforceability. So in spite of this being a domestic agreement, you are putting enforceability. This we had discussed during the lecture. even though this is just a domestic agreement, you can still add enforceability by making it in writing, by registering it. You're showing intention to create legal relation. So yes, definitely this will make a contract, and it is valid. It is validly enforceable. She can file a case and recover the amount from her husband. So there must be intention among the parties to create legal relation. In case of business, commercial transaction, there is a presumption that parties intend to create legal relation, but in case of social or domestic, there is no such presumption. However, even in domestic agreement, party may, by an agreement, intend to create legal relation. So even though this is domestic, I can show intention, like by putting it in writing, getting it registered, showing that the agreement is legally enforceable. So she will succeed, as by entering into a written agreement, Ramesh is showing intention to pay, and if he fails, Lali can take action. So what are the points that they have generally included? The first thing that they have mentioned is enforceability. So enforceability means intention to sue, intention to file a case. If one party defaults, other party can take action. In case of business, or see, even though I know the answer, I always write. I keep on writing. I know I have already explained this to you in the previous question, but I still repeat it, because the more you listen, the more number of times you listen, the better it will be registered in your mind. And you will also start saying the same words that I say. So you will explain enforceability. Enforceability means intention to sue, intention to file a case. If one party defaults, other party can take action. In case of business or commercial agreements, there is an intention to create legal relation. We presume that parties intend to create legal relation, but in case of social or domestic agreement, there is no such presumption. There is no intention to create legal relation. But legal relation can be imposed, and we can enter into a written agreement. We can also get it registered, and we can show enforceability. This much is, I think, sufficient. So here there is one more point which you can include, that by putting it in writing and also getting it registered, we are showing the intention to create legal relation. We are showing that we have an intention to create legal relation. This much is sufficient in provisions. And then yes, analysis is already given to you over here. By entering into a written agreement, he is showing his intention to pay. Therefore, if he fails, Miss Lali can take action. In conclusion, you will write that Miss Lali will succeed in taking action against her husband because the agreement was in writing. Now, many a times in conclusion, they just say son will not be able to recover the amount from father. Miss Lali will succeed. But I always advise my student, write just something about why they will succeed. Why will he be able to recover? So, son will not be able to recover the amount from father as it is a domestic agreement. Miss Lali will succeed in filing the case because there was intention to create legal relation. By putting it in writing, she showed intention to create legal relation. Just half a sentence of reason, like, why that person will succeed or not succeed, or that whether they can recover, they cannot recover. Just something to justify. I agree, you have already written that in the analysis part, but just writing that yes, she will succeed, I feel that is incomplete. And you can also write that yes, she will succeed because there was enforceability. Just write half a sentence. Okay, try it next time. So this was our discussion. This will generally be asked as a 3 to 4 mark question. Most of the weightage will be given to the provisions part, and maybe 1 mark weightage will be given to analysis and half mark for conclusion, similar to the previous question. If you have made mistakes, please don't worry. We have many occasions to shine. Okay, so in fact there are questions after every chapter. So if you make mistakes now, don't repeat it next time, and see the growth, see the improvement you will find. Please give yourself at least 3 to 4 tests time. Okay, Give yourself some time. Don't be too harsh on yourself. You will improve. Please trust me. The more you write, the more you practice, the better you will get at this. So you just need practice, and that is what you will get from these fast track lectures. You need an idea, you need someone to guide you, and I am very sure you will be able to manage very well during your exam. So I am there to guide you, I am there to help you, I am there to show you what you are expected to write. I am there to encourage you to write and practice, but the actual work has to be done by you. And if you take that small effort, exemption is guaranteed. So will you work hard? I am ready to work hard for you. Will you work hard for me? Yes, so let's do it together. Let's aim for excellent marks in your examination, and I'm very sure that this dream will definitely come true. So on this note, let me end my session, and in my next session, I will be discussing with you the next part, that is classification of contract. So I'll see you there.